great time for you to come in, Justin, to talk about our featured topic today, which is the FTC non-compete update. And I want to put things just in a little bit of context before I sort of let you really roll with things here. We've talked about it on the program many times, and generally, employment agreements come in three flavors, and they're sort of on a continuum, with the least restrictive of the three flavors being the most enforceable, and then the most restrictive of the three flavors being the hardest to enforce in court. And so what I'm talking about, of course, the three flavors are a confidentiality agreement, and that's the least restrictive and the easiest to enforce. The middle ground is a non-solicit agreement that usually also contains a confidentiality agreement. And again, middle ground, so it's not as restrictive as the third one, but also not as easily enforced as the first one. And then, of course, there's the heavy hitter one, and that is the non-compete agreement. And usually, not always, but usually a non-compete agreement also contains the other two provisions that we've already talked about, the non-solicit and the confidentiality agreement. And non-compete agreements really are heavy-hitting restrictions because it actually prevents people or restricts people in their ability to go to a competitor of the current employer. And so you're talking about possibly putting somebody out of work. The other two agreements sometimes, but very rarely, can lead to an individual being put out of work. That's usually not the case with the confidentiality agreement, and usually not the case with a non-solicit. But with a non-compete, you're basically trying to restrict somebody from going to work in a new workplace. And Justin's going to cover what took place with the FTC's rule this week on Tuesday, and then I'm going to tie this in just a little bit to the National Labor Relations Board, which all ties back to this Looper-Bright decision of the Supreme Court. So Justin, why don't you share with our audience today what happened this week and kind of how we got here?
Yeah, Bert. So I'll start with how we got to where we are today. As I think most folks who tune into the show probably know, the FTC was in the process of rolling out a very broad non-compete ban. It was frankly broader than I think a lot of practitioners were expecting several years ago when the FTC started looking at the issue. It would have banned essentially all non-compete agreements between employers and employees, with a limited exception for senior executives. The courts were addressing this over the last month and a half. There were a number of lawsuits filed in the middle of the summer. And back in early July, on July 3rd, a court in Texas issued a ruling on a preliminary injunction motion that held the way that most employers were looking for, to find that the law, or that the rule rather, was an unreasonable exercise of the FTC's statutory authority, and that it was arbitrary and capricious, meaning that there wasn't any sound reasoning behind the FTC's exercise of the rule. But
and Justin, let me chime in real quickly. I mean, so that for everybody who doesn't know, the FTC is the Federal Trade Commission, and they deal with trade in the United States, and specifically free trade. And had the FTC ever waded into this area prior to this current presidential administration?
No, Bert, and the FTC's statutory grant is over 100 years old, the FTC Act of 1914. And for much of the FTC's first several decades of existence, really didn't do a whole lot in terms of substantive rulemaking. It's become more active as an agency over the last several decades. But this issue of non-competes has always been one that's been left to the states. Some states have common law rules, judge-made law. Other states have statutes that set boundaries or presumptions for non-competes and restrictive covenants agreements. So this was a very large grab of power by the FTC. And the FTC had looked to some provision of Section 6 of the FTC Act that gives them the ability to regulate unfair methods of competition, but the dispute was over whether or not that gave them substantive ability to implement a non-compete ban of this kind of breadth. And so The court in Texas back in early July signaled, no, we don't think so. That this is an overreach of their congressional authority, and also it just is not a rational rule given the scope of it. It's so far-reaching, and the FTC did not do enough analysis as to whether all non-competes are bad, only some non-competes are bad, whether or not some are actually legitimate protections for business. And so the court said, we're going to issue an injunction. But what was challenging for employers around the country is that the injunction in that Texas case was just limited to the parties in the case. So employers everywhere else were still anticipating this effective date of September 4th. There were two other lawsuits that were ruled on in the last few weeks. Late July, there was a case out of Pennsylvania where a court went the opposite direction and said that this was a proper exercise of the FTC's authority. So now you've got a district court split on the issue. And then you had another case just last week in Florida that ruled similar to the Texas court, a little bit narrower reasoning. The court expressed some, there was some expression that perhaps the FTC has some authority in this space, but ruled that the FTC simply went too far with the blanket ban. And so you've got these divergent court opinions, and all the while, employers are staring down the barrel of this September 4th effective date of the rule. And one of the things that the rule required was for that employers to send out notices to their employees telling them, hey, if you've got a non-compete, it's no longer enforceable. And so employers were stuck in this weird position of thinking this rule probably isn't going to survive. But if we send out these notices and try to comply, we may be inadvertently rescinding our non-competes going forward, even if the rule does fail. So it really left employers in the lurch. Fortunately, the court in Texas, it had indicated it would rule by August 30th. And the court decided, I guess, to rule a little bit earlier to give employers everywhere a little bit of a reprieve. And so,
and of course, so that you and I could talk about this today.
Right, absolutely. Yes. Yeah, no, thank you very much to the court down in Texas. So Tuesday, late in the day on Tuesday, the Texas court issued a ruling on summary judgment, so a final decision on the merits of the case, and again reiterated the same opinion, the same holding that it had reached in the preliminary injunction phase, saying that the FTC likely exceeded its statutory authority, and also that the FTC acted arbitrarily and capriciously in adopting this rule. Again, no reasonable basis for the scope of the rule. In doing so, the court extended the ruling to the entire country. So now we have a nationwide injunction against the effective date of the rule. Now, where do we go from here? So at least in the interim, the urgency of potentially rolling out notices, complying with the rule, that is likely gone by the wayside. There's no need to issue these notices by September 4th, but we can certainly expect the FTC to appeal this. Again, we've got a split in district authority, so I would expect this is going to make its way up to one or more courts of appeals in the coming weeks and months, and very likely to the Supreme Court at some point for a decision. So it may be that the FTC rule is revived. I think most practitioners in the space expect that it probably won't, and that the rule will go into the dustbin of history. And I hesitate to say that with certainty, but in the meantime, employers are not under the gun to do anything or issue any kind of notices. So what should employers do, Bert? I will tell you that regardless of this FTC rule, my advice to employers hasn't changed a whole lot. There are still strong headwinds against non-competes. You alluded to it in your intro to this segment. Courts do not like non-competes, and I think more and more courts are expressing skepticism about non-competes. I'll tell you that in the last few weeks, I've had a number of clients ask about, hey, how do we make sure that our agreements will be enforceable after this FTC rule goes into effect? And I've seen several agreements that have just said, I don't think the FTC rule changes anything because it's not enforceable today. You've got to make sure these agreements are constrained to the areas in which the employee works. Long gone are the days when you can have a non-compete that bars an employee from going to a competitor for any reason. It needs to be limited to the scope and duties that they perform for you as the employer, and to the types of positions that they could harm you in if they were to compete unfairly. So you can't just say you can't go to a competitor and you can't go to a competitor anywhere in the country. Those days, to the extent they existed a few decades ago, are long, long gone. And so I really encourage employers to dust off these agreements, maybe use this as an opportunity to get them up to speed and get them up to date in the law in all the states where they're in effect. And also consider whether or not you even need a non-compete. I tell a lot of my clients, consider not only the practical realities and the difficulties in enforcement, but sometimes there's just cultural reasons, right, that you don't want to have non-competes. Certainly, there are positions and types of roles where they make a lot of sense. Important people in the company, senior executives, R&D people, high-level sales folks, but there may be times when a non-solicit or a confidentiality provision will do the trick. So very much encourage employers to continue looking at these regardless of what ends up happening with the FTC rule.
So I think that's great advice, Justin, completely consistent with what I've been advising people. In fact, for decades now, I've been advising clients that everybody within an organization, everybody should have some form of a confidentiality agreement, from the lowest level employee to the most senior executive. You want
Yep.
to protect the information, and even those need to be, reasonably tailored to protectable, proprietary, confidential information, trade secret information, but everyone really should have some sort of a confidentiality obligation. Salespeople, people who are in intimate contact with customers, that's the ideal time to use a non-solicitation agreement. And then, like you said, the non-compete agreement is for the more senior executives, the higher level people, and some of those higher level salespeople that just by virtue of the fact that they go to a competitor, they could materially harm the company. And so these things aren't something that we would suggest that anybody just simply go on the internet, try to download a non-compete agreement and think that that's sufficient for use in their organization. Some thought needs to be put into the types of agreements you're going to use and the types of employees who you're going to ask to sign these agreements. Now, just real quickly, just because we promised the audience that we would talk about it, don't forget that on May 30th of last year, the National Labor Relations Board General Counsel issued a memorandum declaring her opinion that the proper maintenance and enforcement of non-compete agreements and employment contracts and severance agreements violates the National Labor Relations Act. And I am dealing with two cases right now before the NLRB on this specific issue. I was just told last week that the NLRB is going to issue a complaint on one of these, making it one of the test cases in the country where the NLRB is now trying to wade into this whole area of non-compete, kind of overlapping these two areas of the law. And I think it's important to remind people that in 2022, the General Counsel of the NLRB entered into a memorandum of understanding with both the FTC and the U.S. Department of Justice's Antitrust Division that addressed non-compete agreements in employment. And so I think that it's really significant to show that the Biden administration has been completely focused on eliminating or severely restricting non-compete agreements across the agencies. And I think that this decision related to the FTC, Justin, that you've been talking about is sort of the first shot across the bow by the court system reining this in. And of course, I think this does implicate Looper Bright, which we've been talking about, on deferring to agency rulemaking and agency decisions. And I think that the FTC here, as the court concluded, and I think eventually they'll conclude with the NLRB, that they have way overstepped their boundaries in this area of the law.
Yeah, I think that's likely right. I will note that it would not surprise me at all if we saw some congressional action in this space.
Mm-hmm.
I know that's a bold prediction in today's political climate, but this is an issue that has bipartisan support. There are both Democratic and Republican senators and members of the House who have spoken out against the use of overbroad non-competes. So we may see, even if the courts strike down agency action at the NLRB and the FTC, we may very well see congressional action on this issue. Certainly we'll continue to see it at the state level. So important to stay abreast of these developments.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.